All right, welcome back to another special episode of The Unknown. My name is Michael Volpe. I report from Chicago, Illinois. I live in Chicago, Illinois, and usually report there. That's Cook County, Illinois. And my broadcast partner, Richard Luthman. He never likes to say exactly what city he's in, but for some reason, he's very proud of the county he's in, Lee County. Robert Edward Lee is the namesake of that county. For some reason, they named the county after a loser. But be that as it may, sunny Florida. It might not be sunny, but definitely warm. And last
Oh, it's
week,
sunny today. It's beautiful today.
uh,
Beautiful.
last week we talked about Paul Boyne, and he was in the slammer. But earlier this week, on Tuesday, they let him out. He had an appeal that became moot. In fact, that is what prosecutors argued in their response, that it was moot. That's on Tuesday the 17th. He also had a hearing in front of the judge who put him in the slammer, Peter Brown, who then reverted most of the bail conditions back to where they were when he was out of jail. Now, he did keep some, including that Paul can't look at documents on his own, that he needs to look at them with his attorney. That sounds like a violation of his due process. Um, but since he's been out, there's been a flurry of activity. And so we're going to go through several of the documents, and hopefully I get this one right. Let me see if we've got all right, so we can yeah, so I wanted to start with this because this, I believe, is the most important part of Paul's case. And so the so before, for those who don't know, Paul, I think he's going to finally acknowledge there's a blog called thefamilycourtcircus.com. That blog exposes primarily Connecticut judicial cases all throughout the East Coast, in New England, not only Connecticut. And for the most part, it exposes the cases. It also likes to throw in some anti Semitic, racist, anti-Hispanic, anti-woman, anti almost everything phrases, and at times we'll say things like such and such judge gave this child to a child molester. The only proper thing would be a 50 cal to their head. And then at other times, same judges, their home addresses would be exposed, even though they are a matter of public record. So as a result, they charged him on the under the cyber stalking statute with cyber stalking, which you have argued repeatedly requires more than speech and action. And they are not arguing that there was any action, only the so-called speech on the blog. And so Paul has argued that this is overbroad. We're going to talk about, after we go through this, a case out of Illinois, Relaford, which has become an important case in this area. But what we're looking at now is Judge Peter Brown's order, and he disagrees with us. And so, just very quickly, why does Judge Brown think that the statute is not overbroad, and why does he think that we should continue with this, what you and I both agree is a farcical prosecution of Paul's First Amendment right?
Well, we can take that, well, that which we're looking at, the opinion by Judge Brown, and we can use it for many things. We can use it to paper the bottom of a canary bird cage, or we could use it in lieu of toilet paper. We could use it as kindling for a fireplace because it's worthless. If you look at this, we're talking about Relaford in a second, and Eugene Volokh filed an amicus in the Relaford case, and I'm wondering why he hasn't opined in this case. But what Judge Brown does in this opinion is he effectively sidestepped the First Amendment. In the opinion, Brown conceded the law. He said that the court may dismiss a charge if the speech is clearly protected. But then he concluded that whether Paul Boyne's posts were true threats was a factual question for the jury. Let me say that again. the question of whether the blog posts were true threats in Judge Brown's mind is a factual question for the jury. That is
No,
100% legal error.
let me
That's a
interrupt you.
100%
Let
legal
me interrupt
error.
you. So the blog posts haven't changed. The blog posts at issue haven't changed. So it isn't a factual question because he knows which blog posts they are. And he is basically saying it's not up to me to decide whether or not it is protected by the First Amendment or it's not. It's up to a jury to decide.
Whether speech is protected, Michael, is typically a question of law. It's a threshold issue for the judges. Okay,
Right.
They have to decide early on: does this pass the muster? Because what it does is it shields the First Amendment. It shields speakers from unjust government intrusion. And the Connecticut appellate courts actually disagree with Judge Brown. Okay,
Well,
there's a case that Paul talks about all the time that's called State versus Billings. And that case overturned a stalking conviction based on Facebook posts, saying that the defendant's posts were the criminal conduct, nothing more. The stalking, the speech component, that's not the crime.
Now, does Judge Brown does he talk about that case, and does he talk about why that case doesn't apply in this, or in the, I think you call it an order at this stage, in this order?
He sidesteps the whole thing. He basically leaves it to the jury to figure out whether it's a true threat. And if it's a true threat, then Paul is guilty. And if it's not a true threat in the lay jury's mind, that it's not familiar with the First Amendment, then they're going to leave it to that.
All right, but what about this argument that Judge Brown makes? He says in State versus Marsala, our appellate court disagreed with defendant's claim that the law was unconstitutionally broad, that it was not overbroad. Before the defendant can raise an overbreadth claim, he must first establish that there is a realistic danger that the statute will significantly compromise recognized First Amendment protections of parties before the court. What's wrong with that argument? Has he made this argument that this statute has a realistic danger of significantly compromising recognized First Amendment protections?
What he basically says is that the First Amendment doesn't apply in the state of Connecticut. And the First Amendment does apply, whether it's on its face or not, Michael, through the 14th Amendment. So the on its face issue is a red herring. Okay? The issue really here, and the reasoning that really needs to be looked at, is some of the reasoning that Eugene Volokh had invoked in some of the cases, and some of the commentary that he has. And that when you have a punishment of speech because it causes distress, that's a constitutional non-starter. This entire case is about constitutional distress to three judges in the Connecticut judiciary. It was distress. And distress isn't enough. You know, you could say very, very cruel things. You can say very, very offensive things. You can say very, very distressing things. You can say terrible, terrible things, extremely offensive things.
Look,
that does not cross the threshold to make it into.
Do you know how ridiculous this is? Paul never sent emails directly to any judges threatening them, never sent Facebook messages, text messages. He never made any direct contact with them. They are trying to say that this stalking statute, and let me get back
you have the part right there, Mike, that's going to destroy the whole thing. Go back up.
All right. No. I want to go back to right here. So everything that is supposedly criminal comes in blog posts that anyone can read as long as they go to the website. And he says the defendant must bear the burden on demonstrating the First Amendment even applied to hold otherwise would be to create. No, hold on, that's not the right one. Uh, um, where is the um the statute? Where does he refer to Marsala?
There
Uh,
it is, right? State versus Marsala. The appellate court
right,
disagreed
yeah.
with
So,
defendant.
uh, yeah, that there is a realistic danger that the statute will significantly compromise recognized First Amendment protections of parties not before the court. You're trying to use a stalking statute on someone who does blog posts available to everyone, and you don't think there's a realistic danger that recognized First Amendment protections of parties not
Yeah.
before the court may
And
face?
and part of the other issue, Michael, is that there's language in the statute about a directed course of conduct,
Mhm.
right? So you see that say a person is guilty of stalking in the second degree.
Mhm.
You were just there where there's uh, uh, where there was there's a course of conduct, right?
Mhm.
The course of conduct was directed. Okay.
Mhm.
Um, how can Paul direct conduct if he's publishing something to the entire world? When you
Correct.
publish something, you're not directing conduct anywhere. You're disseminating it to the entire world. It's not
Mhm.
directed conduct.
Mhm.
So that's the public square. It's problematic. This entire thing is
It
problematic.
it is anti First Amendment, and that's why Paul had what was the guy's name? Mario. Oh, what's the guy's last name?
Harry Sarami?
Right. He had a noted First Amendment attorney file an amicus brief, basically making the argument to challenge the assertion made by Judge Brown. Ju- the attorney did argue that this will restrict the First Amendment rights of parties not before the courts. And of course it will. If blog posts can suddenly be considered stalking, then people will be afraid to mention people by name in blog posts because they might face the same stalking statute. Um, I think this is the most important part of Paul's case because when he wins, and I do believe that there's no way he loses, it will begin the process that I think will go quickly from there of eliminating this cyber stalking statute from the books, a statute which has been found, similar ones, very similar ones, have been found to be unconstitutional. So, Paul has repeatedly uh, cited this case from the state of Illinois, the People versus Relaford. Walter Relaford is the guy's name. And why is this case important?
This is a statute that Illinois, where you live,
Mhm.
Illinois had put in on the books, and the language basically tracks almost the same, almost verbatim, to the language under the Connecticut statute.
Mhm.
And the Illinois High Court struck it down. They said that it violates the First Amendment,
So
and it was part and parcel.
the statute itself, according to, and I think this was the appellate court. It might have gone to the Supreme Court, but we've got it at the appellate court. They said that the statute itself was overbroad and thereby violated the First Amendment.
Yeah, because
So in
it
effect,
could capture conduct.
Judge Brown disagrees with the Illinois appellate court here in
He
in substance.
Court and their reasoning. He disagrees with Mashad Boone, which is the D.C. Circuit Court, which had a similar statute on the books that was struck down. He
Mhm.
disagrees with Eugene Volokh, with many other First Amendment scholars that have opined on this issue
Mhm.
about true threat. Now,
Mhm.
um, the problem that we have with the case, the problem that's there is and really, Eugene has talked about this in his right. When he talked to us, he said that some of what Paul had said could be taken as potentially a true threat. The statements, were soaked in violent imagery. Right? He talked about judges in the crosshairs of a rifle, begging for a 308 shot to the head. They were menacing language. They were language that would make people fearful. But
Mhm.
do they qualify as real true threats?
Mhm.
Because Paul sounds less like a literal threat, someone that's in your backyard, and more like, political bombasts, more like
Right.
someone
No,
that's
look, if
doing this to
Paul,
create a
Paul,
rise.
right. Look, if Paul made a video and he was holding a rifle or any kind of a firearm and putting it directly into the camera and said the same thing, that would be one thing. But Paul writes a blog post. Most of that blog post is going through details of a case, leading to a conclusion that a judge either granted custody to a child molester, as in the case of Chris Ambrose, who apparently may testify, or took away all custodial rights from a parent, as in the case of Paul himself and many other parents in Connecticut and the surrounding areas, and then would say something like, "Is this guy begging?" And the imagery is that you are pissing people off to the point where they're going to feel like the only thing they can do is to take matters into their own hands because of the injustice of it. But that is squarely within the First Amendment. It's not a video of Paul pointing a gun and saying, "Judge, I'm coming for you. I know where you live. You live at such and such, and here's the gun I'm going to use." That's not what he did. It's not even close to what he did. So
That,
there,
but there's also what we just said, that it's the judges and the judiciary that were seeking out Paul's site. And so
Mhm,
when they heard that Paul was saying outlandish things, they were tuning in to see what he said next. He wasn't
mhm,
injecting himself into them. And some of the things he was saying can't even be taken literally as threats. When I
mhm.
drive my F-14 over your house, we should drop a missile on it. It's like things that are out of
I
control. It's like,
I
yeah, okay, yeah,
also I want to point
F-14.
out here's an important part, in my opinion, of the Relaford case. This includes messages sent from Relaford to his ex-girlfriend directly, emails, I think, in this case. All right. So this case has directed messages that they still said was unconstitutional. Whereas Paul doesn't even have that. He
And the
wasn't
other part, Mike, is the public as the journalistic thing. There's no journalistic value to the messages that Relaford was sending, but Paul's
correct.
communications, his posts, are not communications; they're actually publications, and so there's
Correct.
a journalistic value to them. That's the difference here, and they don't want to
Correct.
recognize
And
the fact
look,
that there's a journalistic value.
let, let's state the obvious. The reason Paul would say a lot of the stuff you'd say is because that gets attention and then they're shared. It's a form of marketing. No one really thought they were threatening. He puts the 50 cal in because when someone reads that, they're more likely to send it to all of these judges, so they'll all read it. The goal is to get the judiciary to read it. Nobody really thinks he's threatening anyone. And there's nothing wrong with that. And even if you think it's wrong, it's legally not wrong. Maybe you find it distasteful that he would use this form of marketing. Don't read it. But as a matter of law, just trying to get people's attention so they share it and get mad and share it with other people is not against the law.
And the 50 cal language came in after the Bogdosian opinion in the Ninth Circuit came out. Bogdosian was convicted, and his conviction was overturned by the Ninth Circuit Appellate Court, the federal court, when he said, "I'm going to take a 50 cal to Obama's head,"
Mhm.
and he put it on a message board someplace, and they convicted him. Well, the appellate court said no, he's fully
Mhm.
within his rights, the same way as in Watts. They said, if I get drafted, the first thing I'll do with a rifle is shoot LBJ. You're totally
Mhm.
within your rights to use that language. Paul used the 50 cal language in good
Mhm.
faith. Actually, he has a good faith
Right.
defense because he was believing he was uttering protected satirical journalistic speech. He was
Right.
criticizing the
And
system, criticizing public officials, and he was
mhm.
doing it in almost a shock jock way, an outlandish way.
Right. And on the website, the Family Court Circus, he had a page dedicated to the Supreme Court and other high court and sometimes state court opinions, which he would talk, which he'd show and then analyze to say, this is why I'm allowed to say it. Do you really think it's a true threat if you're then also giving legal analysis of why you're allowed to say it? Obviously, you're not really threatening anyone if you're like, oh, and by the way, do you know why I can do this? Well, look at this US Supreme Court case. No actual threat comes along with some analysis of the US Supreme Court for why I'm allowed to say it. The whole thing is utterly ridiculous. And that's why it's very important that Paul wins this case, because it will start the ball rolling to get rid of this law and deem it unconstitutional. And I think they can do it through the legislative process and not through the judicial process. But if he wins, the legislature should know that there is no way you're ever going to convict someone under this thing because it's too broad.
But that's Paul's point. I think Paul's point is that this prosecution isn't meant to convict; it's meant to punish, and that's the problem in and of itself. It's that he is aligned against bad actors inside the Connecticut judiciary, and there are plenty of them. And he believes, his view is that the Connecticut judiciary is the pedophile protection program. That's why he does so much on his thing. He talks about pedophiles all the time. He talks about, child trafficking, but he talks about it in crazy ways. There's no doubt about that. But he believes that there's a pedophile ring afoot in Connecticut, and that judges look the other way when they have pedophiles. And I think that Exhibit A may very well be Christopher Ambrose. We interviewed Mia Ambrose, who credibly accused Christopher Ambrose while she was younger, under the age of 18, to Connecticut DCF. We have the emails of her counsel, her minors counsel, who brought things up to the DCF, who totally ignored her. She made allegations of sexual penetration, very specified about her brothers, about how Christopher Ambrose was engaged in this sexual abuse. And it was ignored. It was ignored by the judges. Every one of the judges in this case, okay, the victim judges, Stewart, Mukauser, and Grossman, all have a connection to the Ambrose case, okay? So from that perspective, I don't think they have a case because they don't have specific intent. This is a journalistic activity of trying to expose what Paul believes is pedophilia and the defense of a pedophile, a very heinous pedophile. And if Paul takes that tact in his defense, I think this case is over.
All right, and I agree, and I want to get to where they make the conclusion, but basically, their argument is that simply saying speech is not enough, and calling that cyber stalking violates the First Amendment. Am I right?
There it is. That's right there. That first paragraph is all you need to really read. Okay.
With regard to the exception for true threat, the Supreme Court has held that a communication qualifies as a true threat if it contains a serious expression of intent to commit an act of unlawful violence. That one?
And the last part, political hyperbole.
Holding that political hyperbole does not constitute a true threat and therefore is protected by the First Amendment. And again, when something is directed,
you've read a lot of Paul's stuff. Okay, do you think that the threats? Let's say there are threats there. There are things there that are threatening. There's imagery that is disturbing. Do you think that you could find that language serious? That it's a serious threat, that you have to take it seriously? It's the type of thing where you have to get up from your computer and go lock your front door, or is it something that is hyperbole? That's the
hyperbole.
I think that it's
hyperbole meant to get attention, to get people worked up so that they tell other people, so that all of those people read his blog, which in effect he did, because the judiciary was tuned into the blog. And I don't know if they would have been if he had left the language out of there. Now, another thing filed, and let me get to the top, is this incorporated motion to dismiss and the alternate to suppress the fruits of an illegal extraterritorial search and seizure. And Todd Bussard, Paul's attorney, along with Kelly Billings, she's now the second, She directed it for a while. So Todd Bussard is making the same argument that we made, not the exact same, but pretty similar, that this all started with a search of Paul's home in Virginia where he was living, and they did get a warrant to search the home, but Connecticut didn't get, I don't know if it's a warrant or an order to take the things seized from his home from the Virginia authorities. And as a result, everything that they got as a result of that search should be dismissed. And if everything they have is dismissed, then they have no case.
The judge in Virginia was named Judge Saylor. So the Connecticut courts, they can say nothing about what happens inside the Commonwealth of Virginia. You needed this to begin with a Virginia judge signing the order to go and do the search. And so the order that was signed by the judge was based on a warrant application by a Virginia law enforcement officer, Virginia State Police, that was cut and pasted from something that Samuel McCord had sent down. Samuel McCord, your girlfriend.
And let me interrupt you. Bussard actually takes the court in his motion through that, showing the emails that are sent by McCord to Michael Sponheimer, who looks like, at best, there he is, a sloppy and lazy law enforcement agent, maybe worse, but I'll give him the benefit of the doubt and just say he's sloppy and lazy. So go on. So he cuts and pastes, but what's wrong with that? Why should he write his own thing if he's given?
Well, okay. Sponheimer goes and you have to do something when you're in law enforcement, and it's a very simple thing you have to do. It's called follow the law. Okay, it's very basic. That's a basic part of due process. And so the law says you have to go get a warrant application, and you have to go, and they did that. They got the warrant application. Judge Saylor signed the warrant application, and then they went to Paul's house at 4 in the morning, 6 in the morning. They come. They have the SWAT team. They come in his house. And then that's where the problem really starts constitutionally, is that they collected all of this stuff. Sammy McCord and somebody else was there, and Paul believes it's Sammy McCord's girlfriend, and we'll get back to that in a second. And then they do their search, and then Sponheimer takes all the materials that they collected, all the artifacts, and handed them to Sammy McCord. Under the law of Virginia, that is a violation of the law. You're supposed to inventory them and the Virginia police. The Virginia State Police should have brought that to their evidence room, inventoried it, made an application to Judge Saylor, right? Say, we executed the warrant. We have all these materials and artifacts. Here's the manifest. We would like permission to transfer it to the Connecticut state authorities. Judge Saylor signs an order transferring it, telling them to transfer it to Connecticut. And then they give it to the Connecticut authorities and establish a chain of custody back to Connecticut, to the Connecticut evidence room. Okay? That didn't happen here. Here's what happened, Mike, and you won't believe this. You said sloppy. Sloppy's not the word. Sammy McCord is there with her girlfriend. Why? They went down to Virginia, okay, the day of the raid. And then Sponheimer handed all of the evidence and the artifacts taken, right? And what did Sammy McCord do? She threw it in her trunk, because she spent 3 weeks on vacation. She went on vacation with her girlfriend to the Delaware coast, to the Virginia coast, and didn't inventory the materials till 3 weeks later.
All right,
we don't know what happened to it for those 3 weeks.
All right, but look, who cares? They got a warrant to search the house. A judge would have given this second order. It's no big deal. So what?
It's not a harmless error. It's a chain of custody problem. That is the most severe chain of custody problem. You cannot prove that what was seized from the house is what's in evidence now and what's in possession. We don't know if there was deterioration, there was tampering, inadvertent tampering. These are sloppy people. We don't know what happened. We don't know if somebody got into the stuff. We don't know if this stuff is missing, in part. If it was, there's too many variables. All this stuff has to go, Mike. It cannot be used in a Connecticut proceeding because it comes from a violation of Virginia law. It's just like the silver platter doctrine. It's like a legally obtained material by Connecticut. Connecticut cannot properly obtain the material from Virginia. Therefore, the material cannot be used. That's what this is in a nutshell. I think that this is a strong argument. I don't think Brown is going to grant it because Brown, I think, is a biased judge. I think the motion that Todd should be filing, Todd Booster, is a motion to disqualify Judge Brown for the reasons that you talked about, I talked about the other day, where he on a Friday he doesn't see how Paul Boyne should have his bail revoked. He comes back on Monday and magically thinks the bail should be revoked, and there's nothing in the record to change. I think he's a biased judge, and I think that that's very, very clear.
Right. It's more than that. Not only did he not see any reason why Paul's bail should be revoked, but he also, agreeing with Todd Bussard, Paul's attorney, said there's a proper, you are ambushing the defense with this prosecution by bringing this up to me with no motion filed. If you want to do this, you file a motion. He files a response. I schedule a hearing. Everybody knows what's happening. That's what he says on Friday. By Monday, apparently he didn't care about any of that and just makes the decision on his own. That's extremely biased. The order that we read dismissing all of that Supreme Court and other courts' opinions of these overbroad statutes is even more evidence. And so both you and I agree that since he's so biased, he'll twist himself into knots and say somehow that it's fine what happened here. Am I right? I mean, he's going to do everything he can to try to get a conviction. But I think even with his best efforts, there's no way 12 citizens will ever convict Paul.
I think that he should get off the case. I think he should recuse. I think he's going to save himself because I think that Paul might actually win in the appellate division on the bail petition that's still pending, because the appellate court could still smack Judge Brown in the pecker because of a doctrine called capable of repetition yet evading review. That's the exception to the mootness doctrine that we see in the court. And that's the argument. Well, Paul's out, so it's moot. But we hear you have a situation that could repeat itself. So
the appeals court
on Monday.
Right. The appeals court may want to take this to make sure Brown doesn't do it again.
And there was already talk that Paul is, quote unquote, violating his conditions of release, and that Brown's going to raise the bond again and put him back in when trial starts. And so Paul's living in fear. He can't prepare for trial. He's got medical issues, and then he's got this extra thing on top of him because the judge is not using bail as it's constitutionally designed under the Eighth Amendment to secure appearance at trial. He's using it as a punitive tool, as a coercive tool, as a cudgel.
Which you're not allowed to.
That's an issue.
Right, which you're not allowed to do. And he's not letting Paul see any of Paul can see the motions and other things that are filed, but he can't see the evidence that the state through discovery is giving his lawyers, which is completely unfair, violates due process. But let's get back to this. So anything else we should know about this motion and the events surrounding it?
Well, in a nutshell, I think is what we talked to is that the second part about this is that they all knew there were huge First Amendment issues with this case, and they all knew there were huge chain of custody issues with this case. The Virginia State Police sent an email to them a few months later saying we have to have a conference on this to figure this out, to all get on the same page, because they knew that there was a procedural irregularity. They knew they hadn't followed the law. And so that becomes a problem. I don't know how, with a straight-faced prosecutor, Jack Doyle, who's going to be taking the stand, it looks like, can say that he can bring this case in good faith, knowing that the procedures were not followed to obtain the evidence. When you're a prosecutor, you have an obligation to present the state's case zealously, but you also have an obligation to see justice done. And when you see something that is wrong, that it's a violation of law, clearly a violation of law, it's not your job to bring it to the judge and let the judge figure it out. If it's clearly a violation of law, you have prosecutorial discretion to say, you know what, this is no good. We can't rely on this as evidence to convict a person to take away their liberty. And I think that this shows a failing of Jack Doyle as a prosecutor. I think that, Justice Robert Jackson wrote a lot about what makes a good prosecutor, because prosecutors have so much power and control over a person, and only the real best and brightest should be the prosecutors, and because it takes not just intelligence and not just skill and not just slickness, but it also takes moral character. It doesn't look like these people have moral character. It looks like these people are morally bankrupt. It looks like these people are it is like a show trial at this point. We found our man, Paul Boyne. He's been pegged, and now we pegged crimes on him. We've tried it for years, and we're going to get our conviction. We're going to get our guy. This is like the worst of the worst that we hear in the justice system, not the best of the best.
Right. I agree. I'm actually hoping that Judge Brown rules against it because this case needs to get to a jury and be dismissed so that the statute under which they filed can be looked at. And I think that's the most important thing because the best outcome over this uh, uh, is to have him be found not guilty and put pressure on the legislature to overturn the law, which is overly broad and unconstitutional. Now, the third thing is a state of Connecticut's notice of intent to offer uncharged misconduct evidence. That's a lot of legalese. What in the world does this document even mean?
So they're trying to say that there are things that Paul did, and they're not trying to say it's character evidence, but they're saying it's a limited series of prior bad acts.
Wait. Limited? This is a 25-page document. How limited is this if it's 25 pages?
I hear you. This is what the standard is. So you're offering this evidence to show elements of crimes. You're asking me to show like elements like notice or intent, lack of a mistake,
now
identity.
It has Paul's voicemails to Detective McCord. How do these voicemails in their mind show any kind of evidence of guilt?
So a lot of this stuff here, and I think Paul's actually going to dispense with a lot of this because he can basically admit, yes, I am the publisher of the blog. Yes, these are my computers. Yes, these are my quote unquote digital artifacts. These are my things. It gets rid of their digital expert. It gets rid of their issues. So if there's no chain of custody, dismissal on that, and this stuff comes in, I think that Paul's best bet is to turn around and say, yeah, all this crap is mine. And so all your claims you're going to spend half the trial trying to establish this stuff is mine. Let's just get to the meat and potatoes that I am the publisher. Is this a true threat or not? I think that the jury will enjoy that a lot more. I think that if Jack comes in and Jack says, oh no, we have to go through every one of these things, he'll lose the jury pretty quick. So the first part is about statements that Paul made on either on the phone or to other people that show, and all the things I said, identity, the ownership, the intent, that type of stuff, not showing the truth of the evidence.
I gotta read this. So he's got a July 5, 2024 call from jail. In this phone call, the defendant is speaking with a caller about his trial specifically. He claims that, quote, the Jews are all behind it. In response to the caller asking him, quote, what do you see happening with the trial? The defendant responds, well, I guarantee you they're not going to wake up one morning and realize that the First Amendment applies. And I need to go home and say, sorry, Mr. Boyne, we can give you a ride to the airport. No, that's not going to happen. So they're going to try and take it to a jury trial. And I don't know how the heck they're going to instruct the jury, but they'll do something. They'll fuck it all up and maybe get a conviction and then, drive it to an appeal. And I mean, they just want to drag it out forever. They said, we can't convict him. We don't like what he wrote, so we'll just fuck with him for years. How does any of that relate?
Read the next sentence. It's an overt admission about the authorship of the blog post. So they're trying to connect him to blog posts. So if Paul admits, I wrote the blog posts, what the hell? I think that helps him. I think that admission helps Paul. It shows that he knew that they were going to fuck with him. They're fucking with him, and it goes to his whole theory of the case. I think this whole document is a botched abortion on behalf of the state. I think that
So then
that Jack Doyle just gave Paul his acquittal. I think all he has to do here is put the state of Connecticut, the three judges on trial, and the central person I think that comes up in here is a man named Christopher Ambrose. His name is within this document multiple times, connected to all three of the judges. And Paul's whole point was that the Connecticut judiciary was looking the other way on pedophiles.
It doesn't come up on mine. But
when they talk about the judges, we'll talk about it.
All right. It might just be not finding it. I spelled it right. But all right. And so then your argument is that he shouldn't admit to it, so they can introduce all of this evidence so that he could then introduce evidence.
Introduce the evidence. He can introduce it in his case. I think he has to present a robust case as to what his journalistic goals were. I think you said it before. You said he should say he was going outlandish. He was going over the top. He was trying to get attention to the issue. But I think part two is the issue that he was trying to call attention to. One of them was pedophilia in the courts and sexual abuse in the courts, and judges that are not cognizant of it that look the other way, and DCF that looks the other way, and that these people, if if you go back to Leviticus, he's a devout Roman Catholic. He's a very religious person. Look at the biblical punishment for someone that engages in that activity, and it's the same for someone who conspires with them. The Leviticus says to be put to death. So if he's talking in these terms, he's talking in biblical terms. He's talking in hyperbolic, biblical terms. So he should put that out there. That should be his case. And who he can call as his witnesses? He can call Bandy Lee. He can call P.I. Manny Gomez. He can call Mia Ambrose. Okay? Christopher Ambrose is the center of the case. He's a star witness, and he's connected to Grossman. He's connected to Stewart. He's connected to Mookhauser. Mookhauser is the one who disqualified Nicola Cuna. The whole Nicola Cuna stuff is in here. They talk about Nicola Cuna in this thing.
Nicola Cuna, she
Go ahead.
represented for a while Ambrose's ex-wife, Karen Riordan. I want to just read this here. This article also relates to charged complainant Grossman, that's Judge Grossman. The article threatens her by stating, when does Judge Grossman get the witchcraft of a 50 cal to her head? Would anyone be surprised? Do you really want that to be illegal? Do you really want something like that to be considered a crime if somebody says something like that in a blog, no less? This wasn't sent directly to the judge. It wasn't sent with a photo of a gun with a 50 cal in it. It's a part of a blog that describes a case. And I think Grossman was on Ambrose's case. It actually might be about Ambrose's case. Do you really want that to be a crime?
Well, and here's the other part. Let's say Paul is right. The reason why we have the First Amendment is, what if the person is right? We have to take offensive words. We have to take, harsh statements and harsh ideas because we are searching for the truth. What if there is a child, and that child is named Mia Ambrose, and that child was abused by her father, and that the judges looked the other way on it, or a judge even took a bribe, or a judge even, was fully cognizant of what was going on, and as Paul insinuates, there's a pedophile ring out there, and they're party to it. Well, that becomes the point. The point becomes, you could have a child who grows up. And we can have a movie that you go see. There's been plenty of them where the child takes revenge on the person who looked the other way. There were stories where they had prison guards that would beat kids while they were in juvie. There were people that did that. There was the one with Gerard Butler where he came back and he planned it while he was in prison and he took everybody out. And that we call that justice. We have that sense of justice in there. This could be a story about justice in the sense that the people that the state is behind, Christopher Ambrose, Judge Mookhauser, Judge Stewart, and Judge Grossman, they could be the villains. We are not sure. They could very well be the villains. And in Paul Boyne's telling, and that's what it is, a journalistic telling, he's entitled to tell his story without being prosecuted for it.
And here's another blog post. Happy day of 8th of March. Happy 308 day. More justice can be dispensed in one bullet than by all of family court. Celebrate the Second Amendment as protection from the pedophiles who run family court. Judicial discretion fails to the report of a rifle. You really want that to be an illegal act in a country with free speech and free press? You want that to be with a picture of a bullet next to it? You want that to be like a violation of the law? Is that what you want? All right, so
the Ambrose stuff is a little bit further, but that's the most important part to this, I think, because right here we go. I think it's coming up. Grossman Mook shower. Let's see.
Right there, Karen Ambrose.
Karen Ambrose
Mook shower presided over the Ambrose case and disbarred one of the named party's lawyers. The lawyer was attorney Nicola Cunha. And he disbarred her because she made a possibly anti-Semitic statement that she apologized for and asked to move on. What Nicola did wasn't right, but ridiculous to give her any more. Right.
Well, look at Judge Grossman. Grossman presided over the Ambrose case. Right. You go about the Stewart. Stewart presided over the Ambrose case. The linking element here is Ambrose, who we know is a credibly accused pedophile and sexual abuser of his own children. Mm-hmm. So, I think this case is over. I really do. All he has to do is call Bandy Lee, who was an attending physician who examined them, P.I. Manny Gomez, who reported this to the Connecticut federal authorities and state authorities. You see, complainant Stewart presided over the Ambrose and Campos cases. Ambrose is the key to this case. And Ambrose is a liar who was run out of Hollywood.
And listen,
Ambrose is incredibly
all of these cases they are referring to are cases that Paul covered in his blog. It is as journalistic an activity as you're going to find. So they are wading deep into a piece of journalism and extracting one or two sentences to say that part, that one specific thing out of a blog post of many paragraphs is a crime. Completely absurd. And yes, in support of protecting these judges who themselves were protecting physical and sexual abusers. Yeah, go ahead.
The star witness in this case for the state looks to be Christopher Ambrose. And I think that this document by Jack Doyle proves, the state attorney for New Haven, Jack Doyle proves that there is a pedophile protection program in the Connecticut judiciary, or at least you could palpably argue it with a straight face based on this documentation and Ambrose being linked through this entire thing as he's like not the bad guy, he's the good guy. And we know that for Mia Ambrose, I believe the victim. I believe Mia Ambrose. You've talked to her too. I think you believe her. Bandy Lee believes her.
There's no doubt that Ambrose was molesting all of his kids. There is zero doubt of that. Okay, I wasn't there. So 99.9% certain. Go ahead.
That's what you believe. Her testimony. If you're a jury, you would believe Mia Ambrose.
Right. Absolutely, it would be guilt beyond a reasonable doubt for sure.
Right. Understand? I believe. Okay, that's what it comes down to. And I think that may happen in this case. This might turn into, because of what Jack Doyle just put in this document, this might turn into a case within a case about the Ambrose case. I think they have to be ready to call Bandy Lee, to call P.I. Manny Gomez, maybe to call Karen Riordan herself, to call Christopher Ambrose. They made her try to keep him out, but also call Mia Ambrose. And you know who the other person they should call, Mike? Who was the commissioner of DCF at the time of the Ambrose case?
I believe that would be Joette Katz.
I think that she should come in too about what DCF did, because they were investigating the allegations at that time.
Look,
I think Joette Katz should be a witness.
Right. Look, that's ultimately what this.
Jack Doyle is a witness again.
Right. We're not just coming up with a defense trick. That really is what this is all about. Uh, is that Paul was exposing them. They didn't like it. They were looking for a way to stop him. They latched onto this completely specious way to charge him. And it is a protection of child molesters. That is why they suspect a child molester is on the witness list. That is why that case keeps coming up in the document that they filed that they believe will help them prove that case, because that custody case is at the center of all of this. All of these judges that claim they're afraid of Paul Boyne, what they're really afraid of is being exposed for the pedophile protectors that they are. Anything you wanted to add?
You said it perfectly.
All right, and we will be back.